Statutory and Administrative Law, two additional sources of law. So we're going to talk today about statutory law and how statutes are proposed, and we're going to talk a little bit about administrative agencies, differences between executive and independent agencies, and we're going to talk about power and control. So statutory law impacts the lives of all Americans. We interact with statutes multiple times a day, whether we realize it or not. Statutes are laws that are created by legislatures. So nationally, laws created by Congress, the Affordable Care Act, or also known as the Obamacare. At the state level, the California State Assembly and the California State Senate create state statutes, such as statutes that allow for the recreational use of marijuana. And then locally, we have ordinances that might be created by the county that you live in or the city that you live in, depending on where you might happen to be. For example, traffic stop signs are generally created by city ordinance, or those speed humps that you see in like neighborhoods where they want people to slow down. Those are usually ordinance driven. Statutes must be signed by the executive branch. So when a statute is in the proposal process, it's referred to as a bill. So there's a bill for X, Y, or Z. That bill is argued in its legislative body, and then it is either signed into law by the executive, or it is vetoed, which means that it is rejected legislation. Locally, that would be the governor signing California state statutes, and nationally, that would be the president signing bills that come out of Congress. So why are bills proposed? Why do we need to create statutes in the first place? Well, sometimes it might be for a new issue or a new worry. In Oceanside, something that has come up relatively consistently is affordable housing. The city council is really wrestling with what this affordable housing, what they can do to help support affordable housing in Oceanside. And so vacation rentals are a big controversial topic because a lot of people are taking their commercial rentals off the market in order to make them short-term rentals. And so the city council might, in fact they did, put a limit on the number of short-term rentals that Oceanside can have, and they put a limit on where they could be. They can only be in the coastal zone of Oceanside, which is, I think, west of El Camino Real, maybe. I forget where that coastal zone is, but it's only in the coastal zone. We might create statutes due to an unpopular judicial ruling. So one of the things that you hear in a post-Roe v. Wade world, where the Supreme Court made a judicial ruling that was very unpopular with folks in a lot of states, is you hear rhetoric about codifying Roe. And what that means is that Congress would create a statute that enshrines a woman's reproductive rights, and if that is signed by the president, that then overturns that unpopular judicial ruling. And then criminal law is always created by statute. The reason for that is that we don't want to give judges or politicians, like not a single politician. And then criminal law is always created by statute. And the reason for that is that we don't want to give judges the power to create and enforce the laws all on their own. Once statutes are created, it's up to the judiciary to interpret those statutes. And so what that means is it's their job to explain when the statute is applied, precisely what the language means and how it applies in a given case. There's three methods that the court uses. The first is the plain meaning rule. And the plain meaning rule basically says that words are interpreted in their plain meaning. So for example, if a statute says something about religion, then they're going to use the plain meaning of the term religion. And that generally would afford, that definition would afford itself to the legally recognized religions in the United States. So Satanism is not a recognized religion. Catholicism is. Judaism is. Scientology is. Mormonism is. The universal worship of cupcakes is not. Okay, so you can't just create your own church and think that it's going to be protected as a religion because it doesn't fit the plain meaning of the term religion. Legislative history and intent. Sometimes laws are created to have a specific outcome. For example, for some reason, recreational marijuana is always the example that pops out of my head. It means nothing. But recreational marijuana use. The legislative history of that is to allow people to recreationally use. That doesn't mean jumping into your job as an Uber driver at your occupation and lighting up a blunt, okay? Recreational use. It's for your own personal use in the confines of your own home. And then public policy. Sometimes you have statutes that are designed to promote or discourage some kind of activity. Decreasing homelessness would be a public policy use that we're seeing a lot of statutes being developed to propagate the decrease in the homeless population. Moving on to administrative law. So we have these legislative bodies that create statutes. Frequently, those legislative bodies are so busy doing the work of legislating that they don't have the ability to enforce, police, or promote lawfulness in these areas. And so what they do is they create administrative agencies that are enabled by legislation to then create and enforce laws where specialized knowledge might be required. So for example, you don't want your local congressperson, even though Congress has the power of the purse and they have the ability to control aviation in the United States, you don't want your local congressperson out at Lindbergh Field in the control tower telling planes when to land and when not to land and inspecting planes and all that stuff. You want folks with specialized knowledge in aviation. And so we have the FAA. Communication, we have the Federal Communications Commission. Education, national education, you get the point. Locally, we also have administrative agencies, the California Department of Labor, the California Department of Motor Vehicles. Okay, and so these are agencies that are designed to create and enforce laws, create and enforce statutes that may have been authorized by the legislative body and then delegated to the administrative agency. And the whole purpose of this is to help regulate our economy and keep everybody in businesses performing on an even playing field. Agencies can be independent or executive. Independent agencies are functionally and operationally different than executive. Executive agencies, directors of executive agencies are appointed by the president. So for example, the head of the Department of Justice is the Attorney General. The president appoints the Attorney General. So in essence, the president has a big say in what it is that the Department of Justice may prioritize, because if he doesn't like what the Attorney General is prioritizing, the president can fire the Attorney General. Back when Donald Trump was president. His attorney general was a guy by the name, his first attorney general was a guy by the name of Jeff Sessions. Jeff Sessions was very interested in curbing marijuana use on a federal level. I already talked about the fact that it's not legal federally, it's illegal in most states. And Jeff Sessions very much wanted to encourage the use of the Department of Justice to be more proactive in getting states to stop this mass legalization of marijuana. That was not something that the president was okay with. Donald Trump really didn't care about marijuana one way or the other, and most presidents have not. And so that was something where he was able to exert some control and say, no, that's not going to be your job. Independent agencies are agencies that are not directed by a director. Instead, they have a board of commissioners that are generally 5 to 7 members, and they share power. Commissioners are appointed by the president, and they are subject to Senate confirmation. And some agencies actually have a bipartisan requirement, which means that they have to have commissioners that come from both major political parties. The executive branch has far less control and say over independent agencies than they do executive agencies. So what is it that agencies do? Agencies make rules. So for example, the FAA makes rules with respect to air travel in the United States. They also have the power to investigate. Somebody is accused of breaking a rule, they have the ability to investigate that. They have the ability to show up and inspect. If you are a pilot walking around the airport, somebody from the FAA can come up and tap on your shoulder and say, hi, Mr. Pilot, Mrs. Pilot, I'm from the FAA. I would like to take a look at your logbooks. I would like to take a look at your logbook. I would like to take a look at your medical certificate, and I would like to take a look at your license and just make sure that you're certified to fly the plane that you happen to be sitting in the pilot seat of. Totally allowable vis-a-vis the FAA's enabling legislation. And then the agency has the power to adjudicate. Let's say that as a pilot, I lose my medical license for some reason. I lose my medical certificate, and so my flying license is then suspended. I have the ability to go to the FAA and say, hey, this is what you did to me. You took my medical license. I want to get it back, and I want to be able to present my case. And they have to hear and adjudicate that kind of case. So power of agencies, rulemaking, investigation, and adjudication. So how do we control all of these agencies? And this is probably the most important part of this, because a lot of people say, well, agencies have too much power, or some people might say that they don't have enough power. Agencies are controlled, first of all, by the judiciary. When you have a decision that is made within the adjudication process of the agency, and you're not happy with it, if it is a federal agency, then you have the right to have the decision appealed to the federal court. If it's a state agency, you have the right to have the decision appealed to a state court. So the judiciary ultimately has the ability to control and review those cases. You frequently see on the Supreme Court docket cases that involve some federal agency somewhere. The FCC, the FAA, the EPA, just about on every docket you will see them somewhere. You have executive control, especially for agencies where there is an executive dependency. Like I said, the president frequently has the ability to hire and fire the head of administrative agencies. The Administrative Procedure Act is the enabling legislation that tells agencies what they can and can't do. The FAA cannot be out there making decisions about what can and you can't hear on TV because that's not part of what it is that they're enabling legislation allows them to. But finally, there is individual, and when I say individual, I mean controlled by and for the people of agencies, because we as Americans have the right to file what's called a Freedom of Information Act or a FOIA request or a public records request to find out what kind of information agencies have and what they're doing with respect to areas within their purview. And so if, for example, I want to know how the FCC is or what they're thinking about children's television, children's programming, I can go and file a Freedom of Information Act request, and I can ask for all of that information. I'm sure it would be thousands and thousands of pages. I probably wouldn't want to go through it myself. But I have the ability then as a private citizen to look through and see what it is that they're doing. And so in many cases, by bringing that information to light, we find out what agencies are doing that we may or may not agree with. And many times that helps to control their activities. Statutory and administrative law, huge influence on our lives, probably a lot of stuff that happens behind the scenes that we don't see or that you may not know about, you may not even think about, and that's okay. But something that you should definitely be aware of when it comes to the legal environment.